Did the Supreme Court of Appeal violate the Constitution? An opinion piece on the IOL website at the beginning of March bore the headline presented as fact: Supreme Court of Appeal violated Section 174 of the Constitution. But is this accurate? I'm Rebecca Davis, senior journalist for the Daily Maverick. The opinion piece in question was written by Sizwe Dlamini, the head of independent newspaper's investigative unit, The Falcons. It is fair to assume that Dlamini may not have written the headline of the article, as this task often falls to sub-editors rather than journalists. But in the article, he repeats the claim that the Supreme Court of Appeal may have violated the Constitution by fielding an all-white bench of judges to hear a recent matter. The case in question involved independent media's holding company, the Sekunjalo Group, owned by businessman Iqbal Survey. It's worth noting that Dlamini does not mention in the article that the news website he is writing for is part of the Sekunjalo stable. This disclosure would ordinarily be best practice in terms of media ethics. This legal saga started when Nedbank became one of reportedly 28 banks to close Sekunjalo accounts following the findings of the Mpati Commission of Inquiry report. That commission looked into wrongdoing at the Public Investment Corporation and found dodgy aspects surrounding the PIC's investment of 4.3 billion rand into a survey-owned tech company whose shares almost immediately lost 90% of their value. Sekunjalo initially succeeded in winning an equality court judgment that Nedbank had to keep their accounts open. But this was overturned by the Supreme Court of Appeal in December 2023 in a scathing judgment which dismissed the idea that Sekunjalo's accounts were being closed as a result of racial discrimination. Since then, independent media has been pushing the narrative that this judgment was questionable because the bench of judges who decided it were all white. A similar opinion piece was tweeted by IOL's Twitter account in January 2024, alongside a graphic which claimed, quote, "Outcry over SCA's all-white bench in discrimination case." The part of the Constitution which independent claims may have been violated is Section 1742, which reads, quote, "The need for the judiciary to reflect broadly the racial and gender composition of South Africa must be considered when judicial officers are appointed." According to the Supreme Court of Appeal website, there are currently 23 judges on the bench. As far as we can establish, 6 of these are white and 17 are black, constitutionally speaking. Some may argue that just over a quarter white judges is an overrepresentation based on population figures, but it is nonetheless clear that a significant majority of the Supreme Court of Appeal judges are black. The Sekunjalo matter was heard by 5 judges, which the Supreme Court of Appeal website says is standard for matters of importance. Cases are allocated by the judge president, who in this case is Judge Mahube Molamela, and the composition of panels change depending on each case. Allocations are normally made simply on the basis of which judge is available. The question of race would never come into it. As such, there is simply no basis to independent media's claims that the country's second highest court violated the Constitution. This is a very serious allegation which has the potential to put a major dent in public confidence in the judiciary. It is factually untrue.